going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Saturday. I had my earbuds in and just realized they weren't connected to my computer. That's not going to work real well. So I just really quickly put my microphone in. I've been having issues with my microphone. There's been a lot of echo lately. So I've been trying not to, use it when I don't have to. It's generally only when I'm on camera. Anyways, I've got some cord, but I want to finish watching Lone Wolves. You guys want to go? No, I don't think I'm allowed to do that. I was just going to go restream or share Lone Wolf's stream. He's going to be joining us shortly anyways. Okay, let's just go ahead. All right, my first clip, Judge Middleton. We got a weird guy. This is a little bit older. It's probably about a week and a half old now. It happened right before I went on vacation, and I haven't shared it yet, but it's a good one. Judge Middleton, weirdo. Okay, before I hit that play button, you know what to do. Hit the like and subscribe. Do your junkie backflips. Let's go.
Fast. We have returned to the preliminary examination and other matters on Dusty Hicks. Mr. Hicks is here with his lawyer, Mr. John Bush. He is in custody. He's charged in file 24998 with 2 counts of resisting and obstructing a police officer as a habitual offender. He also has 6 trespass or disorderly person charges from the city of Three Rivers. We were here on the 24th. I brought the wrong files. Brought tomorrow's files. Laura, would you bring me the Dusty Hicks file? It's in my top tray for this afternoon. Anyway, at the hearing, Mr. Hicks and I had quite a discussion. The offer was a misdemeanor, dismissed the other misdemeanors. He's now been in jail for 24 days.
Yeah, I'm not going to tell you that that's weird. I know a lot of people do dairy with different things. I don't know if I could do dairy with salty. I do dairy with sweet. Just about anything after, anything I eat that's sweet, I always crave milk. I don't know about salty, though. I might have to check that out.
Somebody was, I guess I took it upon myself to contact Lisa Inatelli at the jail. And she is our mental health liaison. And I wrote an email.
Yeah, it's Saturday. Saturdays, it's about 50-50 whether or not I go live or not. But I spent Saturday night with Heather. So if I go live, it's during the afternoon. And yeah, here we are. Afternoon. Hey, what's up, Lou? How are you? Marty, good to see you. Please help me. Siobhan. That last one was a joke. Yeah, no idea. Also, I'm kind of stalling right now because Lone Wolf's going to be joining us, and I don't want to get heavy into this case until he redirects. So yeah, there's going to be a lot of pausing in the first couple minutes of this clip.
And I CC'd it to Tim George, Jeanette Jackson, David Marvin, John Bush, and it was to Lisa, but I never actually sent it. I found it in my drafts this morning. So, Mr. Hicks, I had asked, I found it this afternoon, to have Lisa from the jail meet with you. You've been in jail now for 24 days. We have all of these trespass charges that have been filed against you, and they want to keep you out of that plaza. The resisting obstructing charge allegedly occurred on June 8th. The trespasses start in January. There's a disorderly person in file 24153 from January 23rd. There's a trespass in file 24619 from April 14th. There's a trespass in 24371 from February 8th. There is a trespass in file 24569 from April 8th.
All right, this has nothing to do with court, but I just received an email, which I'm going to say that it's spam. I'm going to go out on a limb and say it's spam, but I just received an email from Blockbuster Video telling me that they have great deals going on right now. I mean, if you're going to pretend to be a company, why are you going to pretend to be a company that barely exists? But yeah, for everyone out there, Blockbuster Video has a lot of really good deals right now. This is hilarious. I'm going to open up this email and read it. This is funny.
There is another trespass, 24663 from April 20th. And then there's a trespass from April 23rd, and then the closest one is June. As I indicated, the city would take a plea to one, dismiss all of the others, and time served 24 days. The problematic case, and the bigger one, is the felony case, where the city offered to, or the county prosecutor offered to reduce it to attempted resisting obstructing a police officer. The problem is you believe that somehow you have ownership or some property interest in a parcel of parking lot there in that plaza. Mr. Hicks, have you given this some thought since I talked to you last week?
I didn't know I assaulted any police officer.
Well, it's resisting. Let's see specifically, which is different than assaulting.
I don't know how I'd be charged with that.
Yes, that's why this was.
No, the thought is through my family heritage, and a lot of my family owned a lot of property in the area. There's some of the rights for me to be in the area when they had built these places and moved in, like Dollar General and Goodwill, stated I had the right to be around there over 100 or 200 feet around the building. I was in an empty area of that building, so I wasn't bothering anyone. And no one came and told me that I was trespassing. The police just show up and say I am.
Well,
I don't know if anyone.
That's not true.
They keep asking me when I
well,
go
the owner keeps calling and saying, please get this guy out of here.
From California.
I'm not sure where he is.
He said he lives in California because I asked why wasn't he down there. Or thought I asked, may not have, but I thought he had to be there just like anybody else to witness that I was the trespasser or I get to see them.
No, he doesn't. Anyway, there was.
I feel I was being harassed a little bit by the police. It's the same police most of the time, but.
Well, it's the same shift. So we're at the same point we were at.
I wasn't, it's just the tribal and the thing in the center, that park, that's affiliated with my bloodline and my family. That's another.
No, he's not saying it was built on a burial ground. I'm pretty sure there are laws where you can't build on burial grounds. If they start digging, even if it's an unknown burial ground, and they find any kind of remains of humans, they have to immediately stop. So no, he's not saying that. He's saying that he's Native American and his heritage owned this land that these buildings are now on. So he's allowed to just do whatever he wants on the property. That's what he's saying. So yeah, unfortunately, there's probably some MH issues going on here. Judge Middleton calls it out here shortly, but this is kind of a wild defense.
Reason why I would be allowed to be down the history of the 7 tribes. It's just like the 3 chiefs of 3 Rivers or Princess Mishawaka. She was born here in 3 Rivers, so it's all heritage, and I'm part of that heritage. So I don't see how I was trespassing. And the symbols on my hand match the pavement. The symbols are dusty. The noble bird, no, it's even in the cell I'm sitting in, electrical.
Was I muted when I was just talking? Was I muted? Did anybody hear me say America? Because it was. I thought it was really cool. I did it in a really cool deep voice. Did anyone else hear that? Please tell me I wasn't muted.
Wires,
Your Honor, I don't know if it's a benefit.
Yeah, I don't
to keep
know.
talking.
We're at the same loggerheads we were. I don't think we have any choice. I'm going to refer.
Man, I did this really cool America, Budweiser beer, America. I was just saying I liked your icon. That's it. I think I realized that I was muted because when I went to mute myself, I wasn't muted anymore. So yeah, it wasn't supposed to be frozen. I was talking. But yeah. Okay. All right. But all it was America. Super cool, deep voice. Yeah. Jake Peralta. Let's go.
Mr. Hicks for competency evaluation.
excuse.
I'm gonna send you
May I
to the
ask why?
forensic center because you have a delusional belief that somehow you have some tribal interest in this property.
It's-
And you continue to go back to it and you continue to be
well, you
arrested.
asked me why.
Well,
Didn't I
I
answer
believe,
why?
I believe you believe what you're telling me.
You're right, but you was asking me that.
Well, I did, and so I'm not mad at you.
Oh, I just thought saying you're
No,
like a priest
but
or
I
something.
don't. Yes,
Oh, I'm part of the Indian.
I think even if you were full-blooded Indian, I'm not sure that you have a claim to ownership of this property. And
Well,
you and I
there
just
is
can't.
paperwork somewhere about the sidewalk. Like the symbol is on the sidewalk. I took pictures, but it's in my backpack.
Paperwork somewhere in some alternate universe. The problem is in this case, the police came and they ended up having a big struggle. You were quite agitated, whether you remembered or not. It was a struggle there in the parking lot, and there were pepper spray and 2 pairs of handcuffs, and you were quite agitated when you got to the jail. And no matter how many times me or the police or someone tells you you can't go back there, you continue to believe that you can go back there. So the question is, are you competent to assist your counsel in defending your case? And are you able to understand the nature of the proceedings against you? I think you understand the charges, but I think you have a delusion that you have a defense. We have a man in Three Rivers, he's not here anymore, but he had what mental health called a baseline delusion that he owned all of the Shell stations. He did not. And he kept going into the Shell stations and pouring himself a cup of coffee and ordering the staff around. And he got arrested about 42 times, literally. When he was on his medication, he did much better. I don't really want to do this, but I don't think I have a choice. We were concerned about how long this would take, but we can't ignore the pink elephant in the room that we're looking at a mental health issue. So I'm still going to ask Lisa Telly to meet with you, but I'm gonna sign an order for a competency evaluation. Mr. O'Bear, the people concur?
Yes, Your Honor.
Mr. Bush?
I think it's necessary. I mean, I've had that concern.
John, you don't have another duty week until Fair Week.
Speaking of Fair Week, I have been talking to our good friend Debbie Davis on my trip up to Three Rivers, and it's going to happen either the weekend of what did she say? The weekend of the 24th or the weekend of the 31st. I'm gonna go up there on Friday to make sure I meet Judge Middleton, but I'm either gonna be up there the Friday before the weekend of the 24th or the 31st. One of the two. So yeah, it's gonna be fun. Also, Jay Hart, thank you so much. Remember for 8 months. 8 months, that's awesome. One of the OGs. Thank you so much, Jay Hart, for that. I appreciate it. What's up, Wixom?
Continue this to June 17th.
Excuse me, you said June 17th?
September, excuse me.
September 17th?
Can be faster. After Lisa meets with him, perhaps we could address a bond issue. But at this point, I'm not confident that if I let him out, he isn't going to go right back to where he was.
I'd like to be out so I can get a job. I mean, if there's gonna be a fine somewhere, I gotta pay it somehow. Otherwise, sitting in there anyway, so the $15-$30 a day that they're gonna screw me over with later anyhow, like they did my license.
I don't think you're gonna be able to pay that, but I understand.
You know, I gotta do something with myself. Sitting in there ain't gonna do nothing.
Yes.
Brick walls, same TV show all day long.
No, I'm not mad. I don't even know who you are. Who is this? You can change your name all you want. I'm just not gonna remember who you are anymore.
What show do they watch?
Well, I like the History Channel, but it's the auctions and whatever that making metal. The name of that is. I'm more into the superheroes and G.I. Joe shows.
Excuse me, what time of day did you say?
That would be 8:30. It can be accelerated. Court will execute a petition for competency evaluation.
So is that for 8:30 or 1 on that?
8:30. The prelim would be the following.
I said thank you to Lone Wolf and PM. I did not say it here. Thank you so much, Lone Wolf, for the raid. I appreciate it. LWU. That sounds like a university. See, Lone Wolf University. No, we need a better name for that. LWU. Now this is the Key and Peele skit when they're announcing all their names. I can't think of a good one. I'll come back.
Following week, which would be September 24th. All right. Miss Lisa from the jail is going to come meet with you. You're always polite, respectful, cordial. We just have a fundamental disagreement on your ownership of this property.
He did share with me today that if he was released, he would probably go to Keystone and ask for housing assistance.
All right, we'll hear what Lisa has to say. All right, Mr.
How long
Hicks.
would that be if she does, if I can get to Keystone? Because by September, they're not gonna want to put me in there. I mean, maybe if they ain't said like the last time that they spent money. I mean, I was just about having employment where we were before I got over here, but you know, they ain't gonna do me no good in here.
All right, well, keep you safe, keep the public safe.
Not a threat. I didn't run.
Well, you're right, although there was a fight here with the police that I don't want to minimize.
I felt like that, I sat down like I stated. I didn't throw
All right, well, don't tell me any more about it, Mr. Hicks, but we need to try to get to the source of this. All right, you're good to go with the officer.
Thank you, Judge.
Thanks, Judge.
Stick around for a minute, gentlemen.
All right, I got it. Definitely not Cromwell. LWU. Woo. And no, Lone Wolf, I'm not going to tell anyone what you just sent me because, yeah, we're not saying that on air. I don't want this to be demonetized. But that was funny. All right, next clip. We're leaving Judge Middleton. I made this 2 hours ago. I already forgot what the next clip is. Where are we going?
I have
Judge Boyd. Oh, okay. So this is a funny one from Judge Boyd. We got two really short ones in a row. This one's about 3 minutes. The next one's about 3 minutes. Let's go.
Dunbar. He's on the Zoom.
So, yeah. All right, Mr. Dunbar, if you'll show your video, please. All right, Mr. Dunbar, thank you for dressing appropriately.
Is that a Rembrandt in this?
No, that's the Lord's Supper behind him. And he has an attorney sitting on his desk. That's awesome. All right, Mr. Dunbar, if you'll unmute, please.
No.
All right, I think that's by Michael.
Angelo.
Michael D'Angelo. Michael.
Who did the?
Yes.
Leonardo.
No, you're right. It's Leonardo da Vinci who did the
Sistine
Chapel. Yeah.
Okay. Oh, okay.
If you see
That may be an original.
all right, then if that's an original, then
You
your
get a
client may
photo.
have picked up another case because that's not supposed to be behind him.
It
Uh,
looks as big as the original.
Mr. Dunbar, we know that's not the original Lord's Supper. You're good.
Maybe those two originals.
Yeah.
Yeah, Mr. Dunbar is sitting there like, what are you guys talking about? I'm here for court. Why are you guys? No idea. And this is the thing. All the court watchers who hang out, watch courts, they know that judges and attorneys have, sense of humors. If it's, your first time in court, especially you're sitting there, you're minding your P's and Q's. You're not going to, start laughing. But I think a lot of us would have played along with that joke, especially with Judge Boyd. But yeah, that is not a Rembrandt or a Michelangelo painting. No, it's not. It's not. He's safe. We understand that.
But no, when I went to the Sistine Chapel, that took a lot of work.
I said that because I know you went there.
Yeah, it was beautiful. I mean, he was doing everything.
He had to do it on his back.
Happy birthday, PCC. Happy birthday. Hope you have a great day. 51st. That's awesome. Thank you for spending your birthday, or at least a little bit part of your birthday with us. That's awesome. Happy birthday.
Yes. Yeah.
Come in.
There was a group of 4 of them, extremely poor, but everybody was hiring them out to do different things like sculpt, paint, do buildings, do everything. All right. So what's happening on this case? Did you receive an offer?
Oh, yes, ma'am. I got an offer today. So we can have a setting. I'll discuss the offer with my client and quite sure we'll be able to resolve it.
All right. So we'll come back on July 30th. And Mr. Dunbar, are you in Bexar County?
No, ma'am. I'm in Harris County, Houston, Texas.
All right. So what we'll do, if there's going to be an agreement or not an agreement, he can still appear by Zoom.
Yes, ma'am.
Because I know Houston, that drive, nobody's doing anything with the traffic.
Okay.
All right. So we will see you back on July 30th, and it'll be by Zoom. Okay.
Yes, ma'am.
All right. Do you have any questions?
No, ma'am.
All right. Don't do any self-surgery. All right. Have a
Thank
good
you,
one.
Judge.
You too.
Oh, that self-surgery joke. That was from the hearing previous to him. Yeah, I don't exactly remember what it was, but it had Judge Boyd saying something about, in movies where they just put a knife into the fire and then they burn the skin on top of a bullet wound. Yeah, don't do that. Something like that. I don't remember. Okay, next one is potential Karen. Okay, this is an interesting Karen because yeah, when you hear her tone and yeah, that's all you need. Her attitude and her tone. She sounds like a Karen. But I don't think she's wrong to be complaining. But yeah. All right, let's go. This is another short one.
Now calling case number 24C2190. This is Swan Creek versus Amber Almany.
Good morning, Honor Attorney Elizabeth Ellison, PA 2098 for the plaintiff.
Amber Almany from Swan Creek, 6988.
Okay, thank you. So your matter is being adjourned to July 10th, 2024. That will be at 2 p.m. in person before Judge Washington and Attorney Ellison, the balance as you have it.
Your Honor, $2,398.53 in rent, court cost of $175, the balance being $2,573.53.
So, Your Honor, I just spoke with Nicole. Actually, she was just at my home, and that's not the ledger that she gave me. We have people working on my home right now. The reason that I did not pay rent is because my house is now a hazard.
Okay, I'm holding. Okay, Ms. Almany, please hold on. Ms. Almany. Okay. We're not having a hearing right now as far as the merits of what's going on, because as magistrate.
All right, I almost forgot to mute her when she said her address. Now, she doesn't have a back door right now. She doesn't have a back door. It's not there. No, I don't know what happened. Maybe she said there's people there right now working on it. Maybe they took it off. I don't know. But yeah, don't show on the internet that you don't have a back door and then happily say your address. I'm glad I muted it. But yeah, don't do that. Don't do that.
As I stated previously, I can't make rulings on any of this. Okay. So you're going to have a hearing in front of the judge next week. If you want to bring pictures, documentation of whatever is going on, then you can bring it to your hearing next week. Okay.
Yes, ma'am. I have documentation of everything. There's been mold found in the walls, etc. Yes.
Okay. Thank you.
That's why I haven't paid. It's not like I just don't pay my rent. I purposely put my rent in escrow.
Okay. Thank you. And that is good to know. Bring documentation of all of that with you to your next court date. Okay.
Yep.
Okay.
They have it as well at the office. I gave it to Nicole yesterday.
Okay. Thank you. Then if you don't have anything else, you are free to mute. You can turn your camera off if you want to and just stay for the presentation. Thank you.
I have a question. I was going to make that payment today. For June's rent. Although the balance that I have again is $1,329. They've agreed to waive some things. But point being is I'm just asking on a legal matter. I've contacted legal aid 3 times without a response. I've called and left a message. This was the first eviction notice that I've gotten. You can't walk in without an eviction notice.
Okay. So
my question is if I don't pay this money, is this going to be an issue where I'm going to be evicted until this is adjourned on the 10th, or do I?
Okay, magistrate Bailey just tried to answer you, and you continue to talk over her. Don't ask compound questions to a judge and expect her to, she's trying to help you as best she can. Oh, that's a good freeze frame right there. Yeah. Again, potential Karen. I have no idea. She has the right to be upset. She really does. But I don't know. Okay, let's finish this one up. It's a short one.
I have to make this payment.
So the case is still ongoing. They can't put you out while the case is still ongoing. The court cannot give you legal advice. Okay. I can put you into a breakout room with the court liaison if you want to talk to her after you've seen the PowerPoint presentation for the advice of rights, but I cannot give you legal advice.
Okay, yes, I would greatly appreciate that.
Okay, thank you. Then I will do that after you have seen the presentation. Okay.
Thank you. Have a great holiday.
Thank you. You too. Now calling
All right, moving on. All right, what do we have next? I've got a long one to finish. Are we? I think this is it. This is the long one. We're not even halfway through the video. All right, Judge Shackelford, we've got a tenant landlord case that we're going to finish with. This one's kind of weird. I haven't seen this one played anywhere. This is another one that's about a week old, but I haven't seen this one anywhere. Landlord tenant, let's go.
This is 24012261LT Jeannie Trombley versus John Cecil and Tawny Denauer. Ma'am, can you tell me your name?
Jenny Trombley.
All right. And Miss Anderson, your appearance?
Good morning, Amber Anderson, P86091 on behalf of defendants.
Okay. And can the two of you tell me your name?
John Cecil.
Tawny Denauer.
All right, so we're here today. We had a special hearing set on this because Lakeshore Legal came in on this case and believed there was a valid defense. So, Ms. Anderson, can you briefly tell me your position on this on behalf of your clients?
Yes, Your Honor. So the plaintiff has filed the eviction case 3 days after the defendants had an inspection done on the property. We believe that this eviction is retaliatory in nature. Furthermore, after looking through some of the documents that the plaintiff sent over, it does not appear that she had a certificate of occupancy or registered this as a rental.
Okay, what's the statute you're relying on?
Sorry, give me 1 second. It is MCL 600.5720.
Okay. So I received a lot of documents from both parties. A few of them were too small for me to read. And I see that there were several civil infractions or issued on the property or ordinance violations from incidents. It looks like they came out or inspected on March 11th, and 3 tickets were issued on 4/1 for litter, trash, and rubbish, accessory structure maintenance, and storage of recreational vehicles. So those came in on April 1st. And then I see there were 2 other tickets on 3/25/24 for registration and certificate of compliance for failure to have that on rental property. Ma'am, would you previously have this property listed as rental property?
No.
Okay, so it was not listed. It was not registered with the city, and it had not had a C of O?
I believe it had a C of O way back several years ago. My brother lived in it. He passed away. I inadvertently completely forgot to register it as a rental. When I was notified to do so by the city, I did it immediately.
All right, so that's in compliance at this point? All right, I did not receive anything on the date that the tenant requested an inspection. I have a ton of text messages, tickets, other information, but nobody produced that information to me. So
we're not
saying it, I need evidence. I mean, it's the day for the hearing, and I specifically requested all of these exhibits and information so that I could make a decision or a ruling on this case, and nobody produced when that was requested.
Your Honor, can I say something?
Sure.
I went down to the city the day of our last hearing to request the inspection report. and I had to fill out a paper, and they said it takes 5 business days to get it.
Did they know the day you requested the
Yes. Yes, I
What day
wrote
was
it
that?
all. Yeah, I wrote it all on the request. I told them we had court today.
Well,
and they
tell me, I don't have the request. Tell me, when did you do that?
Oh, I did this on first thing Friday morning. I went in and I requested it. I filled out the
Not here.
paper.
Slow down, that's not helping me. Ms. Trombley, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Cecil and Ms. Denauer, I need to see you one at a time. Mr. Cecil, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Ms. Denauer, right hand up. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, Mr. Cecil, I am asking you, I'm not asking you when you went over last week. When was the date that you requested the inspection?
No, it wasn't the 11th.
That's what you told her about.
Oh, yes. I requested it on the 11th of April, and they came out the following Friday after I requested it.
Do you have anything to contradict that? Do you know the date you requested the inspection?
I have it.
Okay, can you bring it up? I don't have a court officer in here, so don't
I have.
get wily.
And it was
All right,
requested at the
thank you.
same time.
Okay, thank you. All right, I have, what is this? Mailing address, inspection date. Is this when you requested it?
Yes.
Is this after you got this ticket in March?
No, prior to.
All right, I have a document in front of me that I'm seeing for the first time, and I don't know, Miss Anderson, it's a City of Taylor Building Department. The owner is listed as Jenny Trombley, and it's the property at issue here in Kensington. And it's a application date of 4/4/24. And that's her rental registration, so she paid that. And then on 4/4/24, it looks like Miss Trombley went in. She paid the registration fee for the rental property and requested a home inspection because you needed that to get your certificate of occupancy, ma'am. So on 4/4, she has date stamped copies, and we can scan and email this over to you, Miss Anderson, so you can review this.
Okay.
Miss Motley, is it possible? Nobody's allowed to talk because I don't have a court reporter while this is being copied. And here's this thing.
Do it.
Okay, we're on recess, no talking.
Oh man, I know I'm gonna fast forward this. Let's see how long it takes me.
Was there a history of Lent?
Hey, can you guys hear me though? I changed out my microphone. I put my earbuds in. Just testing to make sure you guys can hear me. No talking. Spade is right. No talking. Stop talking. Stop talking.
Ms. Trombley, do you have some sort of accounting?
All right, here we go. We're back.
Ms. Trombley, do you have some sort of accounting you keep as a landlord of when you receive rental payments? Do you have some sort of
Yes,
log?
I do, but I don't have it with me. Receipts each month on the date.
Was there a history of Lent rate? Sorry, let me try that again.
Every month.
Late rental payments. So they.
Did she just say what I think she said? Is there a history of RAPE? That's what she said. Nah, no, that's not what she late rental, but she added those words together really fast and didn't sound good. All right, I'm glad my earbuds are working. I connected them correctly. Also, you guys want to have a bonus clip tonight? Or tonight? this afternoon. Got a bonus clip. I'm gonna play it tomorrow morning. But if you guys want a bonus clip after this, let me know. It's a good soft sit video.
Moved in when? August of 23?
Correct.
Okay, in August of 23. And now so it's just coming up on a year.
Correct.
But you don't have any documentation to show those late rental payments?
Not with me.
Okay. Which one of you submitted all of I got two, chunks of information, but it didn't tell me whose was whose. Who submitted all of the text messages?
I did.
Okay, and you had a chance to review them, Miss Anderson?
I only received a handful of pictures from the plaintiff. She did try to send them to me, but entered my email incorrectly. And then when she tried to forward them, the actual contents did not go through.
Did you get the email from Miss Maudlin?
I have not received it yet.
Will you check your junk box? Sometimes our email lots of people get our email sent to their junk for some reason. It's not come back to me. And it's not come back as undeliverable.
My junk box has never come back as undeliverable. Just saying. It's never undeliverable. TMI? Too soon? I don't know.
I just don't want her to have to send you another stack and you not receive them either. It's okay. I just have a seat. It's okay. I need to let Miss Maudlin get what she's doing done.
I was just gonna let you know that I have the emails actually in order.
Okay, give us just a moment, okay? We'll have a chance to look at everything. This is the only matter we have this morning, but we have to do it right. And I want to make sure Miss Maudlin can do all of the jobs I'm asking her to do. Matter of fact, Amy, while you're doing that, I'll go scan these.
Judge walked away again.
You put it in my folder? No talking while I'm out. I'll scan them to your folder.
Yeah, no talking. No talking while she's out. Stop talking to everybody. Can't talk while she's not here. Okay, she's back. Are we still no talking? Apparently. The judge is doing the talking. I will not stop you. I will not. Oh, a soft sit's best scenario. Best case scenario for a soft sit. A judge walked away from the bench. They should start trying to prove jurisdiction right now because she left the bench. She left. Okay, fair. Not my turn yet. Yeah, she straight up bounced. Like, all right, gotta go get some things. You guys don't talk. No, I don't know what we're waiting for.
Okay, one of them came through.
Okay. I'm going to be honest. Well, here's the problem. The first thing I need to know to proceed on a case like this, the most important question is, when did the tenant exercise their rights? And I had chunks of documents that were submitted to the court, and the one document that's missing is when the tenant exercised their rights and requested an inspection. So that's a big problem because there has to be some showing that there was an exercise of rights for this statute to even be triggered. And I don't have that. I don't know when they requested an inspection. I know from the documents that Ms. Trombley provided that she requested an inspection on the rental property on 4/4. I know that the notice to quit was sent on 4/14. So I can only assume, I mean, that it's the defendant's position that they request.
Hey, I've got a girlfriend in Canada. I do. I promise. I do. She's real. She's real people. I promise.
Did the inspection within 90 days before 4/14.
It was
But
4/11.
I love your name. I care. Everyone else can just hush if they don't like it. Your name's awesome. G.
4/11 is the day I went to the city and requested the inspection.
Ms. Trombley, when did you receive your rent for the month of January? Do you know, Mr. Cecil? When did you pay January's rent? She's looking through her phone or through emails or text messages. Do you know when you paid January's rent?
Probably by, I don't know exactly what day. No, I couldn't tell you exactly what day.
Do you know when you paid February?
I mean, I can look through my text messages and see, because her and I text back and forth.
I know, but there's still an agreement. I understand it's month to month, but I'm gonna I mean, Miss Anderson, you could jump in if you have questions for either witness, but I'm just trying to resolve this. Ms. Trombley's indicated the reason that she had filed for the inspection, before Mr. Cecil did. She's also indicated that rent has been consistently late and documents were submitted showing that multiple tickets have been issued on the property for non-compliance with city ordinances. And I believe I received 4 separate. There were tickets on 4 tickets on April 4th or April 1st.
January 7th.
So you received January's rent on January 7th. When did you receive February's rent? Wait, do you have a practice, ma'am? Do you send a receipt via email?
I give it to him in person when he pays the rent.
Okay, you give it to him in person. Sir, do you dispute that the rent was paid on January 7th?
No, I don't dispute that. And the reason, can I say something? I'm sorry.
Oh, yeah, go ahead.
Okay, so yes, I pay the rent late every month, but I work the job I work. Sometimes I don't. My money it's not sporadic. I have money, but it just comes at different times of the month. So, and I have no problem paying the late fees, like her late fees. I pay them no problem, no questions asked. And I mean, I'm not trying to be dumb, but if there was no rental, the house wasn't registered as a rental with the city, how can she even collect rent?
So how can you even live there? If we're going that route?
No,
I'm asking you, then how do you live there? I mean, do you think that because Ms. Trombley was out of compliance with the city ordinance requirement that you should be able to live for free?
No, that's not what I'm saying at all. And as far as the ticket, she only told us we had 1 ticket to pay. She's never let us know about any warnings or anything. And the stuff I got a warning about, they put on my front door and I took care of that. She only told me I had one ticket to pay of $185. So all these other tickets, I had no idea about after that.
There was a litter, trash, and rubbish ticket. There was
Yeah,
an
we can-
accessory structure maintenance ticket. I saw messages about that, or some sort of temporary carport that was put up on a cement slab. I saw messages about that in the text messages between you and Ms. Trombley that were submitted to this court.
Yep.
And then there was storage of recreational vehicles was another one.
Yeah, that was the next door neighbor. That's not even our house. That's why I was trying to fight that one, and she would not make a court date to fight the ticket.
Isn't that the picture?
Kayla, definitely not. Spade, Texas. Yeah, I am definitely AI. I am AI. And Heather is a hired actress. She is, which I'm lucky to get her at such a low rate, because she charges people a lot more to pretend to be their girlfriend than me. So yeah, no, I'm very lucky.
Of the trailer, the camper that was in front of the house.
No, that was after that. I got a warning after that and took that camper down. There was 2 campers that are parking. Me and the neighbor share a lot. Half of it's his, half of it belongs to this house. He has 2 campers parked in the back of the lot, and that's what the guy wrote the ticket on. That camper came after that ticket was even wrote, and that was gone. He gave me a warning for that, and I took care of that after that.
All right, well, Ms. Trombley received a ticket for it.
She never told me.
All right, here's the thing. Miss Anderson, the way this statute works is there's a presumption that it's a retaliation or a retaliatory eviction if it happens within 90 days for his request for an inspection. Unless the plaintiff here, Ms. Trombley, can establish by the preponderance of the evidence that it wasn't retaliatory. Preponderance of the evidence is a very low standard. It's 51%. So far I see that she's received, prior to his request for the inspection, and it looks like this event was actually the kickoff for her asking for the inspection on 4/1. So she requested an inspection before he exercised his right to request an inspection, which leads me to believe she wasn't mad he asked for one, because she had already asked for one herself. I also have what appears to be a history of late rental payments. There were text messages that I reviewed where on a regular basis, Mr. Cecil would text her and say, hey, I'll have it on Friday. A late fee is not even due until after Friday. And then it would be Friday would come and he would say, I'll have it for you by Wednesday. I would put brakes on my car, or something happened with my vehicle or something or another. And I mean, was your rent late? When did you get February rent?
February came February 21st.
She received February's rent on 2/21. That's her testimony under oath. What about March? What are you looking at, ma'am? Are these notes or
the text messages?
The messages, okay.
Your Honor, the defendants have stated that they owe rent, or that they have paid rent since then. I was not able to get a receipt from them, but looking at the text message on June 3rd, it appears that he might have paid rent. That would make it June 7th.
All right, did you get March rent? When did you get March rent? We're gonna.
All right. So this guy, This guy thinks it's okay to pay rent whenever he wants to throughout the month. He's like, oh, I'll just pay the late fees. It's fine. When I have the money, I'll pay it. It doesn't work that way. There are very few landlords that would accept that. I will pay you anywhere between the 1st and the 30th of the month. I will pay the late fees after the 1st. But I never know when I get paid. Yeah, that doesn't work. Doesn't work. That would work with a family member, and that's about it.
Go through. Let's see where we are.
March 6th, he said he was on his way.
All right, 3/6, you got March. When did you get April's rent?
Not completely.
You still haven't gotten?
Correct.
Did you get
$800 in April?
All right, 800. What did you get in May?
1,200.
I'll let you go back. All right, Mr. Cecil, what was that? You did 1,200 what?
1,200 for April. I gave her 800, then another 400. I'm not disputing that we owe rent. I'm not disputing that at all. But then she gave us the notice to quit on the 14th of April, and then that's when we stopped. I've paid rent every month. We've never been behind. We've been late. We've never been behind until after the notice to quit.
If she had a mortgage on this property, I don't know if you do or not, but if she had a mortgage on this property and it's a rental home, if her mortgage is due on February 10th, you're supposed to pay her on February 1st. She doesn't get it till February 21st. I mean, you're paying rent 21 days late.
I understand.
It's
Yes.
a significant problem for a landlord.
I fully understand.
And here I am, I'm with this statute. I've reviewed the statute. It's clear that for her to go forward on this, I have some evidence, I have testimonial evidence, no documentation that the tenant requested the inspection on 4/11. I have actual documentation that the plaintiff requested it 2 weeks prior or a week prior on 4/4. So in terms of, when I'm looking at what is retaliatory in a landlord tenant case, he exercised a right. He gets the presumption. But Ms. Trombley has shown evidence that he's consistently paid late his rent. She's requested the very same inspection that he requested prior to his request by a week. And she's received multiple civil infractions because of the way the property was kept. She was cited by the city of Taylor and she's the landlord. So ultimately that's her responsibility. So when I look at all of those things, it's clear to me that she's met the burden of showing this was not retaliatory. And Ms. Anderson, I'll hear arguments if you have one.
I don't have anything further at this time.
Okay, the facts are the facts, right? And Ms. Anderson, I don't, you should have pursued this. I appreciate that you did, and that Mr. Cecil and Mr. Nauer had the opportunity to have someone that would look at these documents for them and give them representation. But on a termination in Tennessee, Ms. Trombley, you own the property at the address of 24391 Kensington, Taylor, Michigan?
That's correct.
Okay. And did you provide a 30-day notice to quit to the tenants at that property?
I did.
Okay. And did you provide a proof of service to the court showing that you had sent them that?
I did.
Who did you rent the property to John Cecil and Tawny Denauer?
I did.
Do you wish to continue to rent to them?
No.
And again, I have that notice to quit was filed with the court and was sent out on 4/14/24. Mr. Cecil, you rent from the landlord, is that correct?
Yes, I'm sorry, can I say something though?
You
I'm
can.
sorry. Okay, so she gave me the notice to quit, okay? And then after she gave me the notice to quit, she came to collect more rent. So I asked her, I said, I'm confused. And you've got the text messages. I said, I'm confused. Do you want us to move out? Or do you want us to pay the money and stay? After the notice to quit, she said, yes, just pay me and you can stay. So at that point, I gave her 800, then another 400. And then she.
All right. This is actually very important. So when a landlord goes through the motion of evicting someone, they're not allowed to collect rent. They're allowed to ask for a money judgment at the end, but they can't collect rent. So, but they didn't have the rent. So like, yeah, if you pay rent, you can stay. And then they started making partial payments. You know, I'm sorry, but if you're fighting to stay in a place, have the rent ready in case that happens, or be looking for a place to move out. This guy did neither. So I have no sympathy for this guy whatsoever. Also, I've got about 3 or 4 people that said they wanted to see the bonus soft sit case that I'll play after this. If I get a couple more people that say they want to see it, I'll play it. Otherwise, we're gonna have the end of the video. I don't know. I don't know where I was going with that. Okay, let's go.
She comes back with again, wait another month after that to get out again. So I'm so confused on, okay, it was issued on April, whatever, but after that, she told us we could stay if we paid. So I don't understand.
Did you pay your May's rent?
No, I was paying April's and that I was catching up April's rent. And then she told us now the eviction stands again, like 3 weeks after I started making up my payment.
So you did not pay May?
No.
Did you pay June?
No.
Did you pay July's rent yesterday?
No, because the attorney said after the notice to quit, then I'm just very confused about the whole notice to quit and then her saying we could stay after that. And that if we caught up.
Do you want to go into a breakout room with your attorney?
No, I don't. I just am not understanding the notice to quit thing.
You received a notice to vacate the property.
But then she told us after that we could stay.
So you think you should be able to live there for another rent-free month, Mr. Cecil? And she should have to go through the process all over again? Listen to me, she's back 2 months on rent. I understand that, but you're not paying to live there. You've lived there for free for 2 months. You've lived there for free for 2 months. You've not paid any rent. You consistently paid your rent late. I am confined by the law. I just am. You got the notice to quit. She filed the paperwork in the court and everything's filed according to how it should be.
Okay.
Miss Denauer.
Yes.
You rent from Ms. Trombley at the address I put on the record?
Yes.
And you do not own the property, is that correct?
Correct.
Okay. There is nothing that I can do under the law to allow you to stay in that property. You were given proper notice. The true owner no longer wishes to do business with you. And you must vacate the property.
Yeah, I'm not asking to stay. We're just looking for a reasonable amount of time to vacate.
What is reasonable to you?
I mean, 30 days.
The statute allows for 10. Ms. Trombley, are you willing to give them a little more time to find a location to move out?
I'm sorry.
Are you willing to give them a little more time?
10 days would be fine.
She's given you 10 days. That's all I have under law. Unless she agrees to give you more, I can't give you more.
I just don't understand how you expect somebody to find a place in 10 days. Because she kept going back and forth on whether we could stay or not.
I didn't see anything in the text messages that said you could stay. I mean, if there were other messages, today's the day I would have seen them.
Oh my God. Like, I have a whole ass family and a whole house. Like, I can't find a place in 10 days.
You haven't paid in months. You've had that much time to get out, to look for another place. You knew she was going through the eviction process. You knew she wanted you out of that place. All that time, you weren't paying. And then when she said, okay, yeah, if you pay, you can stay, and you paid like what, 25% of what you owed? Not good, man. Not good. Also, Doc Ock, good to see you, man. Good to see you, Doc Ock. Also, J Hart, bonus clip, please. Thank you so much for the super chat, J Hart. I will be playing the soft sit bonus clip. This video has about a minute left, so coming shortly.
I mean, I'll pay her the past 2 months' rent. I'm not worried about that.
There is nothing under the law that I have. There's no statute that allows me to extend that. I don't have the authority to do it. I have to follow the landlord tenant statutes and the court rules. And this is what the court rules say. Sometimes landlords allow parties to stay longer so that they can find alternate housing. But if Ms. Trombley is not willing to give you a longer time frame, I can't do it. I don't have any law that says I can extend this 10 days.
I mean, if I start paying the rent I owe her today, will she let it stay a little longer?
If he pays everything current, he has to the end of the month.
She said if you pay, well, I mean, how is he gonna do, I mean, like, let's be realistic. The rent's $1,200 a month. You've got $3,000 just sitting around.
I mean, I have some money, yes, but I mean, I can't pay it all in one day. But I mean, I can take her $300-400 a day for the next week or whatever it is.
Ms. Trombley is not willing to extend it.
Yeah, I mean, at this point, I don't think this guy understands what he's arguing. His defense attorney needs to step into this. I know she's just legal aid, but she needs to step in. So if she would agree to that, or if the tenant would agree to this, yeah, I have $3,000 I can pay you today. I'll pay you this. Can you give us till the end of the month? That's $3,000 going away from the place that you're about to move into. Just saying. Move in. Use that money to move to a different place. You have a whole ass family, as you just said. Use that money to go someplace else. And then if she asks for a money judgment, work out a payment plan. This is just smart budgeting on my part. This guy needs to be thinking. He's not thinking.
So you have 10 days to leave the property, vacate the property. And then after that 10 days, Ms. Trombley, you can come up to the court and request a writ for eviction. That's what the law requires I do. I'm following the law, and that's the ruling. And we're all set today. Thank you, everybody.
All right, bonus clip time. Now you know the rules. When I play a bonus clip, that means, so this video is going to be put out tomorrow morning. When I put this out, you don't have to rewatch it, even though I'd appreciate it if you did, but you got to go click on it and hit the like button at least. That's what you have to do. All right, let's go. What's going on?
And you read your. Is it Marquise?
All right, Judge Oakley. Judge Oakley. We all love Judge Oakley. He's one of the softer. I'm not going to say softer. That's not the right word. He's very kind-hearted when it comes to judging. but he also is. He's gonna put his foot down. He's gonna put his foot down. We've seen him do it before. He has a radical two sides of being extremely kind and then not putting up with shit. And yeah, sob sit, Judge Oakley, let's go.
Marcus, come on up. Are you going forward today without a court-appointed attorney? Okay. And you read your rights?
Yes.
Understand those rights?
Yep.
Understand the options?
Yep.
Understand the possible penalty?
Yep.
Understanding all of that, are you pleading guilty freely and voluntarily?
Yes.
All right. Tell me what was going on roughly May 21, 24 regarding attendance.
Braden has some.
Braden?
Yeah, he has some issues regarding, his mother, so he's in therapy now and we're working to get it.
How old is he?
8.
Great. Where's he in therapy at?
Where's he? Team Wellness.
Oh, great. Great. Yeah. We know the program well.
Yeah.
Good.
So we're working to get it resolved.
Okay. So basically he just got crap and that was keeping him from focusing on school.
Yeah.
So he's dealing with his crap.
Yes.
Okay. How often is he going? Every 2 weeks? Once a month?
Once a month,
How long has he been doing that?
since January.
Oh, good.
So
he's.
All right, this is the case prior. I'm sorry, guys. This is the case prior. I didn't edit this out. But yeah, no, I know Team Skeptic did this. I saw it. Not a lot of people covered Judge Oakley, so I thought I had a few days to be able to play this. So this was going to be a weekend clip. Once I saw that he did it, I was going to wait till Sunday to give him a few days before I played it. But yeah, it still needs some editing. I got to edit this part out. But yeah, rough draft. Let's go.
He's got a good start.
We're
Okay.
trying.
Okay. He seemed to be benefiting from the counseling?
Yes.
Okay. All right, good. All right, so did you hear how this works?
Yeah.
Can you stay out of trouble for 12 months?
Yeah.
Okay. If you're having any problems, same thing. I'm gonna have the officer give you Miss Oswald's card.
Sounds good.
And she knows Team Wellness, so she'd be happy to hear that that's where it's
Alrighty.
at. Okay. Anything else?
Nope.
Have a great day.
Thank you.
You're welcome.
This is Judge Oakley. He is out of Michigan. I don't know where in Michigan Judge Oakley is. I don't know. Someone can Google it real quick and let the chat know, but he is in Michigan. I know that. I watch him just about every day. The reason why not a lot of people cover him is because you can only see him. And sometimes his audio is kind of bad with the people, the defendants and the prosecutors. So yeah. That's why I thought I had a few days to share this clip. I was going to save it for this morning because weekend clips are a little bit difficult. There's not a lot of court going on, not a lot of people hanging around to watch court, probably for the same reasons. So this was going to be my morning clip, but Team Skeptic did play this. Love Team Skeptic, by the way, but I was giving him a few days before I shared the same clip. So this is going to be my clip tomorrow. All right, now we're on to the sovereign citizen.
Matthew, is it Crucell or Crucell? Crucell, come on up. Actually, we got a motion today, don't we?
We do.
You got a motion filed?
Yeah, yes, absolutely. I actually have issues to discuss before I cross.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent order that was since been signed by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check or something.
That's fine, just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yes, I have a few in there that I've been repeatedly trying
Okay,
to be
well, which one
dismissed.
do you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that
too
stuff.
many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're gonna deal with them one at a time. So what do you want to deal with first? You want to
Well,
deal
my
with the
main motion.
default?
Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, what, Don't suppose it's your motion, brother. Tell me what it is.
Well, it keeps getting.
I mean, that's
set
the only
aside, so
civil
I
infraction.
have numerous,
Hold
I
on,
have lots of stuff.
Hold on,
going
that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yes,
about
it was over
that
the-
charge.
Yeah, sure. it was over
Okay.
that.
So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified, I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation, there was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in
Okay,
the
hold
order.
on, hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I
of the
said
ticket.
it's in there, it's attached to my motions.
Okay, do you have a copy
Yes,
of the
I
ticket?
do.
Okay, then I'm gonna ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before, there's nothing.
Okay, but
Yeah, man bun, sandals, and socks. Probably wearing a tank top. But he's in court, right? So he's going to be respectful. He's probably got a Hawaiian shirt over his tank top with his socks and sandals and his man bun. Probably a puka shell necklace and way too many bracelets. That's what I'm going for, and probably barbed wire tattoo around his arm. All right, I think we fairly painted this picture of a person we can't see.
it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets, it says, if you fail to contact court within the specified amount of time, there was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my
Well, let
attorney.
me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Crucell,
contact the
Mr.
court.
Crucell, this is gonna go a lot easier on everybody if you just answer the question I asked. I'm gonna give you plenty of chance to give me any argument you wanna give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm gonna take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once
attorneys.
again, I'm gonna draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that. I don't even think it specifies a date.
Well, did you make a note when you received it?
This told me, this said I had I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than a.
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
well, once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crucell brought this up when we were in front of the Honorable Judge Martin. She did set aside the default in the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crucell did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default already been set aside.
Yes.
Brother, why'd you just waste 5 minutes of my life?
Since March 14th, Your Honor.
Which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I
No,
object
no,
to.
no, 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 wait, listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to issue warrants.
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
The fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, they'd have been issued.
What money did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside, and Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues.
She didn't try to set it aside, she sat it aside.
But she can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
No, she never did. No one did. It's written in my motion.
Sir, I'm gonna hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a
Get him, Judge. Get him. This guy's your, he's a genius. He's a courtroom genius. He knows exactly what to say every single time. And the judge is clueless. He has no idea what's going on. The sovereign citizen is going to win this. Man bun, puka shell, Hawaiian shirts with a tank top, sandals with socks. He's got this. He's got this. I bet he wears skinny jeans too. He's got it. He's so good. He's so good. Yeah.
yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some
of.
point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
And that's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
Absolutely.
Okay, hold on. I denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my motion.
object. You can appeal.
Okay. Well, I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judge.
I'm objecting to you telling me to appeal an objection. I object. All of the objections, I win. I stand on top of my rights. I am the living, bleeding man known as the all caps Colin, definitely not Cromwell. You are wrong, Judge. I object to your objections about my appeal rights. Lauren the pet lover just Googled and Judge Oakley is in Romulus area. Thank you so much. Thank you so much, Lauren. And thank you for the $2 super chat. I appreciate it. I appreciate it.
Just have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we are in Sibley and Middlebelt, right near actually to where I got pulled over. And we had discussed it and talked about it, and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to this sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. And like I said, I even told him, I've already had this, I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well,
is that a fair summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry versus Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry versus Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry versus Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the First Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reason?
Yes, I actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an
Sir,
ORV.
your objections mean shit to me, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care, all right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying.
Get him, Judge. Get him. I love it. I love it. Again, it takes a lot to get Judge Oakley to cross that line, and he just did. He's like, you know, I'm getting frustrated with you, man. This is Judge Oakley getting frustrated. He never does. Well, rarely. I'll say rarely. Don't say never. Rarely does. This is awesome.
Label what my private property is an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial, for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand.
I don't think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it's like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that
Mr.
as well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
Well,
right?
The officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws.
That
the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions at trial?
Well, honestly, in the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own recording.
But sir, stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. Okay. So was the 200?
He doesn't even try to talk him out of it. Most judges would give him a speech. Like, that's not a good idea. Gives them the whole attorneys are practiced in the court procedures and know the court of law and know what to do and how to enter evidence. You don't know how to do that. Didn't do any of that. Just said, good luck. All right, moving on. Love it.
$280 posted as a bond when the initial default happened?
I believe so. I know.
Do you
that-
have any record of $280? Because we're not getting receipts in the files anymore.
I have the receipt right here, Your Honor.
Okay. I'll return your 280 today. Anything else today? All right, let's talk about a date for jury trial.
Which one would you like?
What was that?
September 16th or September 23rd? They're both Mondays.
Maybe 23rd.
23rd?
8:30. All right, now, Mr. Crusoe, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh.
You might say that. You don't understand the rules. Okay? How many jury trials have you had?
None, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can. And that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right.
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
All right, everybody. It is that time. There's only about a minute left of this clip. Thank you all for hanging out with me. Thank you for the super chats and the membership milestones. I appreciate you guys. Yeah. I'm going to release this video as, it's on video tomorrow. Clearly, I need to edit a little bit more, which is fine. But I will do so. And yeah, all I ask is jump on it, hit a like. Hit the like button. Bonus clip. Yeah, you know how it works. All right. You guys have a great Saturday night. I am off tonight, which is why I went live now instead of later. I will be spending the night with Heather. I will be live tomorrow night. Yeah, look forward to this video with proper commentary tomorrow. All right. Have a great Saturday night. Don't do anything dumb. If you do, I will cover you. So be safe. Just think before you do anything dumb. You don't want me to cover you. You don't want to be on my channel. Trust me, you don't. Unless you do. Unless it's a goal. And yeah, just give me a heads up that you're going to be in jail. And, whatever. Okay. That's all I got. You guys have a great night. Have a great weekend. Until next time. Bye.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else?
Okay.
Have a nice day.
Thank you.